Members of the panel, my name is Albert Backrack. May it please the Court, I'd like to split my time, 12 minutes and 3 minutes for rebuttal. This is a black-letter law case wherein the trial court below found that Ms. Poole, the appellee in this matter, was entitled to a set-off against my client, the appellant, Frank Walker, pursuant to Florida law as part and parcel of a partition of real property in Alachua County, Florida. Although not clearly laid out in the brief, the background of this case is that Mr. Walker was married to Ms. Poole's sister, that the property in question was originally owned by Mrs. Walker, the late Mrs. Walker, and her mother. When her mother died, her mother's one-half share in the property became the property of her three daughters, Ms. Walker, who then had one-half plus one-third of half, her sister, Ms. Poole, and another sister, Ms. Rogers, who is survived by the additional appellee, Christopher Rogers, and a sister who's not participating in this property. That leaves us...
Well, counsel, let's sort of jump through, because we know that the parties were tenants in common.
Yes, sir.
Is that correct? So the question, going way back into the common law, the issue, each tenant in common has the right to possession.
Absolutely, Your Honor.
And where there becomes a disagreement, the remedy of partition is developed. And it's what we're dealing with here is the issue of ouster within this body of law, is it not? So isn't the focus of this case whether or not ouster was established?
Absolutely, Your Honor.
Okay. Now, you argue that there's no evidence that Walker was holding the property adversely to Poole.
Yes, Your Honor.
What about the communication referenced by the trial court when Walker refused to vacate the property upon the termination of his life estate, or where Poole was required to obtain a court order in order to partly possess the property to fulfill her duties as executor? Why aren't those facts evidence of ouster?
Well, let me back up 2 steps and go forward, because I think that's easier to do. Stokely versus Connor, which is the case we rely on from the Florida Supreme Court in 1915, establishes that exclusive possession by one of the tenants in common does not establish ouster or anything like it, nor does the keeping of all rents and profits from the property by the person in possession. So, using that guidance, you have to show both acts that are inconsistent to the rights of the co-tenants, and you have to make a statement to the co-tenants that they have no legal right to the property. That is, under Florida law...
Did you say exclusive possession is not an ouster? Possession, that means possession to the exclusion of the other co-tenants.
The Florida Supreme Court said that if you have exclusive possession, if you're just the only one of the co-tenants on the property, I think that they meant it in terms of if there were 3 siblings, one of them is living on the farm, one of them's living in Jacksonville, one of them's living in Atlanta. The fact that one of them's got exclusive possession of the farm and farming it and keeping all of the profit does not create an ouster. That's my understanding of what the Supreme Court said.
I think that's correct, but what if the brother in Jacksonville says, I want to move on the farm and farm it with you, and the brother on the farm says, no, you stay away?
Well, then that takes you to Chastain v. Chastain, or Chastain v. Chastain, which is your case from 1968. Back around 1940, when Grandpa dies, one of the brothers does exactly that. He says, I'm the owner of the farm, I'm going to keep the farm, don't come to the farm, and everything coasts along till 20-something years later, at which point the two children that were survivors of a brother who had predeceased the grandparents said, we own a heir's estate in this real property, and came up for the first DCA. And the issue that the court narrowly decided there was, without the uncle having ever said to these particular co-tenants, the grandchildren of the original owner, that he had fee simple title to this property and exclusive ownership of it, they weren't ousted.
But there's no specific words that are required to prove ouster, is there? I mean, isn't it a facts and circumstances test? Because rarely where you have people in disagreement do you have something said that specifically. It's sort of human nature. And I go back to my first question, is why aren't the facts that we have here sufficient to show ouster?
Because under the facts and circumstances analysis that you want to use, the courts have never reached that particular conclusion that it's a touchy-feely issue. The courts require specific action by the person to deny the title in the other co-tenants. I think a case that we argued in the trial court, Kogan v. Kogan, which was the second DCA that got reversed by the Florida Supreme Court in 1970, is a post-divorce issue. The husband was a doctor, and one of the properties owned by the husband and wife during the course of their marriage was a professional building which housed the husband's practice. After the dissolution of marriage, they owned that property as co-tenants. The wife was never there. The husband ran his practice there. They never had any discussion about it whatsoever. He just kept the exclusive possession, in the sense of being the only one there, of this property. And so with regard to...
Help me understand with what did happen and the things that Judge Van Nortwood pointed out, what is lacking, in your view, from them having established an ouster here? What didn't happen that should have?
Well, Mr. Walker never claimed that Ms. Poole or Mr. Rogers didn't have an ownership interest in this property. The claim of lack of ownership interest, as Judge Van Nortwood pointed out, was Ms. Poole, who through counsel claimed that Mr. Walker had no ownership interest. Ms. Poole claimed that upon his remarriage, his life estate in the property was terminated, and that therefore he should vacate the premises. That's the appellee's position, trying to oust the appellant. You can't turn around and use the appellee trying to oust the appellant as evidence that the appellant ousted the appellee. That's really Alice in Wonderland. So what really happened was that Ms. Poole wanted to oust Mr. Walker, but in fact, by operation of Florida law, as the widower in this case, he was entitled to his wife's interest in their property. And so he now has 2/3 of the property, to Ms. Poole's 1/3, where I sort of started, to Mr. Rogers' 1/12. But he never said, you all don't have any interest in this property. He never claimed that he was the only owner of the property. And that is absolutely, in my opinion, black letter law in Florida with regard to ouster. You have to claim that the other person has no title interest.
Let me digress for a second, because
Sure.
that letter that you're talking about was very confusing to me. Is that what the law is, that upon remarriage, a surviving spouse's constitutional life estate in homestead property ceases?
No. But it was a confusion on the part of Ms. Poole as to how Mr. Walker's interest in the property evolved under the law. She was looking at it, I believe, as an issue or artifact of her sister's will, which provided for a life estate as long as he remained single. But under Florida law with regard to husbands and wives and homesteads, she was in fact entitled to that share. So it was kind of an apples and oranges thing. She was absolutely correct that he got remarried and the facts of her sister's will, but that did not divest him because he was also entitled to the property.
But was he wasn't entitled to that property in fee simple by Constitution. He was entitled to it, a life estate in it. I mean, had she tried to divest him of it in her will, doesn't the Constitution give him a life estate in that property? I mean, maybe we're talking about an issue that really isn't an issue.
It's an issue I'm not prepared to talk about, but I believe that under Florida law, as opposed to the Florida Constitution, it's his property in fee simple as to the two-thirds interest. It's not a life estate.
And he said, but while mother and daughter lived, each had an undivided half interest.
Yes.
Upon the mother's death, that daughter got 2/3, another daughter got 1/6, the heirs of the third daughter got
Ben,
the 12.
let me cut you off just to get the numbers correct between us. The mother died leaving 3 heirs, so 1/3 of 1/2 goes to each of them. The original daughter who owned half then had 1/2 plus 1/3, or she had
1/2 plus 1/6, or 2/3.
Yes, thank you. And the other daughter, who had a 1/6, didn't survive her mother, I believe, and so the two Rogers children each have 1/12. So having been picayune about your numbers, what's your actual question, sir?
Well, all right, so was the trial judge said because he refused to vacate, that constituted an ouster?
Pretty much.
In other words, you say this record supports the view that he's saying, come on over whenever.
The appellee, Ms. Poole, and the appellant, Mr. Walker, do not have a friendly relationship like that. And I doubt that there's been any time since the death of his wife that they've had a conversation in which my client, the appellant, said, come on over.
Well, let me ask this, because at this point, we're not, the court ordered partition, and it sounds like with the relationship, that's probably the best thing for all concerned. The only issue that's on appeal at this point is the set-off that the court is requiring or taking from, whatever the proper terminology would be, your client, based upon the finding that there was an ouster, and therefore the profits and costs had to be accounted for, I mean, in essence, right?
Pretty much, yeah.
Okay.
And we're saying that doesn't work. What the trial judge was trying to accomplish was an equitable solution to a legal problem. And I'm not here to argue that somehow this is inequitable in terms of the order, that you couldn't make a really decent argument either way. I mean, I could certainly argue for Ms. Poole or for Mr. Walker with regard to the various equities the parties have. But it's not an equitable issue. It's a matter of law. And as a matter of law, my client did not oust Ms. Poole or Mr. Rogers from this property. Living on the property doesn't do it.
Because your rationale that there was no ouster is centered on the fact that he never made a claim of exclusive ownership, irrespective of the actions that he may have taken or the trial court may have interpreted as a denial of access to a co-tenant, correct?
Well, the trial court specifically, said as a basis of his order at page 26 of the June 18th, 2009 hearing, is what I'm finding is from Mr. Ireland's letter, which was sent, I believe, in September of 06. and said to Mr. Walker, your lifetime tenancy is terminated. We want you to vacate so we can sell the property. And he says, no, I'm staying here, that these are acts that are inconsistent with the possession of the other co-tenants, and I'm finding that he ousted them. And that's just not the law.
All right, I'm afraid you've exhausted your time. We will give you an additional 3 minutes for rebuttal. And Madam Clerk, please add 3 minutes for Mr. Ireland.
Thank you, Your Honor.
May it please the Court. I do not believe that you will find in the cases, and we've set this out in our brief, and maybe jumping around here, but that ownership is the issue. In other words, to have an ouster, you don't have to claim exclusive ownership. You claim exclusive possession. And I believe the record is clear in this case. At least it was clear to Judge Roundtree, who heard this case on more than one occasion, that there had been an ouster. We started off.
Let me interrupt you real quick. That claim of exclusive possession is a claim against a co-tenant who also wants possession, right?
Correct.
So you can be in exclusive possession with the agreement and acquiescence of the other co-tenants, and the law is clear that's not an ouster.
You can stay there till the cows come home.
But as soon as one of the other co-tenants says, I want to exercise my rights of possession as a co-tenant, you say no, you have an ouster.
You don't even have to say no. Because I think that's what's being argued here, that there was no voiced statement by Mr. Walker to Ms. Poole, no, you can't come in this house. But in September 2006, before we filed this partition suit, I wrote the letter that you have, and he did nothing. The record is also clear that she paid $8,000, at least $8,000 on one occasion to take the house out of foreclosure. She had
But the letter you wrote said, we want you out of there.
Pardon me?
The letter you wrote him asked him to vacate.
Yes, we did.
And by declining to vacate, is it your position that he asserted possession that could not be shared with the other co-tenants?
By declining to vacate, by continuing to live there with his new, I think after that he got married. I don't know the day that he got married, but he brought another spouse in there. It's ludicrous to think that Mrs. Poole or anybody else, any of the other co-tenants could have gone in there and lived. And also,
Counsel, what about the communication? It seems to me the Florida Supreme Court does say it's not simply the act of an exclusive possession, but you have to communicate to the others the knowledge that you claim an exclusive possessory right.
communication can be done more than by voice. And
I understand, but how was the communication done here?
The communication was, you get out. He says, no, I'm not going to get out. Well, he doesn't say, no, I'm not going to get out. He just doesn't get out. And he stays in there for 3 years.
And that is the fact that he didn't respond and didn't move is a communication?
And on other occasions, whenever we had to get an order to get her into the house to collect, to make an inventory, there were 2 times that she had to get a court order. One's not in this file, it's in the probate file. But she had to get an order on 2 occasions to get into the house to do her duties as personal representative of the estate. I don't think any case could have been clearer.
Was that prior to the September 8 letter?
It was June 18th, no, I'm sorry, June 21st, 2006. So June 21st, 2006, there was a motion filed in the probate file asking to get her in there. An order was entered on August 1st, 2006. Then on June 18th, 2009, there was another motion filed to let her get into the house, and there was an order entered that date.
So the trial court here did not address those as part of the ouster. The trial court said the ouster was on September 8, 2006, and continued from said date.
Correct. But the trial court had the benefit of both of those orders. One is in this file, and the other is in the probate file, and I represent to you that this judge was a judge on in that probate proceeding. Yes, Your Honor.
Your position is that Ms. Poole, as a co-owner, shouldn't have had to go get a court order to get in a house that she owned in common.
She had a right to possession.
And by him essentially forcing her to go that route, that's further evidence of the ouster.
I think there's plenty of evidence of ouster in this case.
What was the proof that he forced her to go that route?
Only the fact that the order was entered that there was a motion filed, and the motion is in the court file, saying that she wanted to get in the house and he would not let her in the house. There was a hearing held on it, and there was an order entered by the trial court. That's the best evidence I have of it.
Did he appear and resist?
I do not know. I'm not sure. I cannot represent that. But I know he appeared by counsel. Whether he appeared in person, I do not know.
Do you know what position counsel took on his behalf?
I believe that order, I know the first order was stipulated to after you had to get to the courthouse. I'm not sure what happened in the second order. They may have it, I don't know whether it's a stipulated order, but it was entered the same day the motion was filed, so it's pretty good evidence that it was stipulated.
Well, my question, and this may just show my complete ignorance of the area, but if I understood opposing counsel correctly, he said, well, he couldn't really argue this order was inequitable. It is, I mean, you've got partition and you've got an accounting. Isn't it? In order to overturn an accounting, don't you have to demonstrate some inequity?
I would suspect that you would.
I mean, is it entirely hinge on the legalities of ouster or not, or is the what happens in the accounting a little broader?
Well, I think their position is, and I certainly don't want to argue their case, but I think their position is that there should not have been a surcharge against him for monies that she paid, probably $20-some thousand that she paid to protect the property, because she had never been, quote, ousted. Our position is she was ousted, and she was required to pay that money or suffer losing her interest in the property.
Now, well, it seems like even if they'd all been living there together, that she should have been given credit for that contribution.
That would seem that way to me. Although, really, you can argue against that, saying that if she's living there, she's getting the benefit of living there. And now she's getting the benefit of nothing. He's getting the benefit of her living there, and he now wants to take the position that he shouldn't pay anything for it.
Well, but now, is a third of what she expended charged to her?
Yes, that's right. Well, whatever her proportionate share was,
right,
would be charged to her. And that's the way that
So he's saying, I need a free ride here.
Exactly. 3 years.
And this accounting is an equitable proceeding, and they're up here saying, we don't want to pay.
That's the way I read it. If y'all don't have any other questions, I think I've said about as much as I can say on this issue. I believe the record is clear. Judge Roundtree was correct, and I would respectfully ask that you affirm.
All right, thank you.
Members of the panel, first of all, Judge Weddle, we're both wrong. Under the Constitution, it's a life estate if the widower, if the deceased person, the widow or widower, has minor children as well as a spouse. When there's no minor children, as in this case, they get a fee simple title to whatever the interest is. My co-counsel knows these things of how the things work. Which takes us to Judge Benton. There is no accounting in this case. There's no pleading for an accounting. There's no accounting being done. It's just a partition action. And under the partition action, nobody's entitled to a share of the co-tenant's money after the property's sold because of any money expended by that co-tenant. As a matter of fact, under the case law, it would only be if my client, Mr. Walker, who was in possession of this house, had asked Ms. Poole and his nephew for a contribution with regard to the upkeep of the property, that they would be entitled to fair market rental value from Mr. Poole. It's the flip side of what was just argued at the court. So if the co-tenant in possession requests from the other co-tenants that they contribute to the cost of the property or maintaining the property or anything similar to that, that triggers the co-tenants being able to then ask the court for the reasonable value of the rental of the property to the co-tenant that's got the exclusive use, as we're using that term. That's just not part of our case. There is no request for contribution. There is no accounting, which would certainly be an easy out in this matter, because if we were dealing with equitable principles, you could make a very good argument. But dealing with legal principles, there's a hackneyed phrase, we are a nation of laws and not men.
Well, actually, partition is an equitable proceeding.
I'll bow to the court on that one. Even if it is, there is no subpart in a partition action for an accounting under the facts and circumstances of this case.
I think we may, at least I may have been using the term accounting and contribution somewhat loosely. I think what we are talking about is a situation, if there is an ouster, and I know that's the $64 question in this case, if there is an ouster, you agree that at that point there are set-offs and those sorts of things that can occur. You're not disputing that the trial court properly did the set-offs. It's just, in the mathematical sense, you're just disputing that he should have never done them because there was no ouster.
Yeah, the trial court worked backwards from first principles. The trial court wanted to do the set-off. And in order to do the set-off, you had to find that there was an ouster. And so the trial court said, there's an ouster. And we spent like 15, 20 minutes together with me saying, well, not really, Judge, look at this case. Well, not really, Judge, look at this case. And every time I would give him a case, he would say, I'm going to find there's an ouster. Go take it to the panel at the first DCA. So I'm here because I'm taking it to the panel at the first DCA because there's no ouster. There's a case I didn't talk about first time up, and I'd like to try and cover in like 30 seconds because, excuse me.
Why don't you just...
Very briefly, you're beyond your time.
Shouldn't flip the pages. Thank you, Your Honors.
All right, thank you.